Hey guys, so okay, we're gonna just start going through these Dalbert motion oppositions. There are two different formats. So when the Dalbert motions were filed 2 weeks ago, they Lively sort of filed hers completely differently to Wayfarer in the sense that Lively filed oppositions to each of Wayfarer's experts individually as their own standalone motions. Wayfarer, however, did an entire document, like 100 and plus, over 100 pages. I think it was close to 170. Um, what they have done for the opposition is they have followed the same format. So where Wayfarer filed their really big document covering all of Lively's experts, Lively has responded in the same way. So when we do Blake Lively's, it's one great big document. And what I'm going to do is do a video for each expert, I think, to break that up. And then likewise, Wayfarer have then responded to oppose Lively's motion to exclude each of their experts as standalone motions. So it makes my life easier in many ways when they do that. But, I'm kind of good. So we're going to go through the first of Wayfarer's oppositions. Blake Lively is seeking to exclude the opinions and testimony of their expert, Michael Wagner. So, and Wagner is basically, he's a rebuttal damages expert. So he's to rebut, I think it's Kinrick. We'll see more as we go through it, but I'm pretty sure Kinrick is one of the Lively experts he's seeking to rebut. And we're going to go through this now and just see, right, this is Wayfarer's argument for why their own expert should be allowed to testify and give their opinions. And it's only, I think the actual motion is only about 6 pages long, so this is not a long motion at all. Okay. Lively's motion to exclude defendant's rebuttal damages expert Michael Wagner mischaracterizes Wagner's opinions and confuses the roles of affirmative and rebuttal experts. Wagner, whose qualifications cannot be seriously questioned, performed precisely the task charged to rebuttal expert witnesses. He criticized the methodologies and opinions of Lively's experts. Each of Wagner's opinions is the product of reliable principles and methods and will help the jury understand the evidence. The motion to exclude should be denied. Okay, so the first argument. Rebuttal experts have a less demanding task than affirmative experts. I'm just looking at this. Footnote, actually, that come with the end of that first opening paragraph. Lively filed identical memoranda seeking the same relief. Neither was signed by Lively's attorney of record as required by... Oh, yeah, she didn't sign her motion. She didn't sign her motion. Because I remember someone saying, oh, who wrote this? And when I went to look, there was no signature. So Wayfarer are actually seeking the court to strike her motion based on that alone. Because I remember saying, oh, Lively's got a real issue with not signing things. I think I made that point. But yes, the memorandas that Lively actually filed two. She filed two identical motions trying to exclude Michael Wagner's testimony. And actually, I've got them up. So this is docket number 1315, right? And this is the start bit. And if we go to the bottom, there's no signature. That's the end of it. That's the end of the entire document. There's no signature page, which there needs to be. And then likewise, if I just share the other screen, so this is document 1330. Yeah, so sorry, this is, if we go back to 1335, I didn't introduce that very well. I'll try that again. This is 1335, Plaintiff Blake Lively's motion to exclude testimony of Michael Wagner. And you can see at the top, document 1315, right? And again, just to show you, no signature page. And then you go to document 1330, right? So it's a different docket number. Again, no signature page. That's the end of the document. So, yep, they are right, and they are seeking to have those motions stricken because they are not signed. And I remember when I was reading it, I was like, oh, there's no signature. Is this getting to be a pattern of Blake Lively? But yeah, Wayfarer did actually pick up on that. Okay. Okay, so let's continue. Rebuttal experts have a less demanding task than affirmative experts, which is true. Wagner is a rebuttal expert. Defendants are not calling him to provide an alternative damages calculation, but to explain the methodological flaws in the opinions of Lively's damages experts. While rebuttal experts are not excused from the rigours of Rule 702, it is well established that they have a less demanding task because they have no burden to produce models or methods of their own. They only need attack those of plaintiffs' experts. This is because the task of a rebuttal expert is different from that of an affirmative expert. A rebuttal expert by nature criticizes the methodology and or opinions of another. Rebuttal can be properly undertaken by poking holes in another's arguments. Rebuttal does not require deploying a ground-up analysis of the very same argument. Disagreement with an expert's conclusions are not a basis for exclusion. Rather, the opposing party may question those conclusions via cross-examination. The overall theme of Lively's motion is that Wagner fails to offer his own methodology and fails to offer affirmative opinions. Those arguments are misplaced. For example, Lively attacks Wagner for opining that various alternative causes could have caused the decline in sales for Lively's brand, without opining on alternative causes that actually caused the decline. But as a rebuttal expert, Wagner has no burden to show what actually caused the decline in sales. Rather, his evidence is offered to show the jury that the opinions offered by Lively's experts are not sufficiently supported and do not take into consideration all the relevant factors they should have considered in arriving at the damages opinions. Without Wagner's rebuttal testimony, the jury will simply assume that Lively's experts did what experts in the field usually do. They did not. And defendants must be permitted to offer testimony to explain why. So the next argument is that Wagner is qualified to critique Lively's damages experts. A witness may qualify as an expert based on his knowledge, skill, experience, training, or education. Lively does not seriously challenge Wagner's overall qualifications as a damages expert and does not challenge his qualifications to opine on a brand's underperformance, and for good reason. I feel like we're building up for something here, a storm. Wagner holds both a Master's of Business Administration and a Juris Doctor. He has decades of experience as a certified public accountant, including as a partner at Price Waterhouse. Wow. Where oh, here's the punchline. Where he worked alongside Lively's own damages expert, Jeffrey Kinrick. Oh my god, I'm sorry. The filings lately are sending me. So what they're saying is, Yet Lively's not challenging his qualification to be a damages expert because he used to work with her own expert. That's amazing. He has well, let me start that again. He has specialized in computation of commercial damages for almost 50 years and has been qualified and testified as an expert 147 times at trial and 39 times in arbitration. He has authored 33 publications, the majority of which deal with commercial damages, and was the editor of Litigation Services Handbook. I mean, that's a really quite impressive resume for being a trial witness, expert witness in this type of trial. Contrary to Lively's contention, Wagner is not being offered as a legal expert, an expert in social media manipulation, or an expert in the entertainment industry. He is being offered solely as a rebuttal damages expert. Okay. Wagner should be permitted to critique Kinrick's opinion that profits earned by Lively's brands would inexorably flow through to Lively. Wagner will critique the simplistic testimony of Lively's brand damages expert Jeffrey Kinrick that Lively's damages may be calculated as the difference between the but-for profits for Lively's brands and the actual profits in each case, multiplied by Miss Lively's ownership percentage in the relevant companies. Wagner will explain why this formula does not in fact capture true cash flow damages to Lively associated with lost sales. Contrary to Lively's contentions, this is not an opinion on legal standing, nor are defendants seeking to launder legal arguments through the authority of an expert witness. Rather, Wagner assumes that Lively does have standing and offers a critique of Kinrick's methodology and measure of damages. For instance, Wagner faults Kinrick's analysis because simply multiplying by Blake Lively's ownership percentage does not make it lost cash flow damages to Blake Lively. Wagner explains that to properly calculate Lively's lost profits, Kinrick would need to establish lost cash flow to her directly. Wagner also appropriately criticizes Kinrick's unsupported assumption that Lively owns 100% of Lol Hatter, the entity through which she owns a stake in Betty B and Family Hive. Wagner further criticizes Kinrick because the evidence Kinrick reviewed does not demonstrate that any cash would flow to Lively, while the projections Kinrick reviewed indicated a need for a cash infusion rather than distributions. Wagner will not testify about the legal standing and will not refer to case law. Wagner's opinions are consistent with the purpose of standard rebuttal expert opinions, criticism of Lively's experts' methodology. Wagner should be permitted to critique Lively's experts' failure to consider alternative causes of Lively's alleged losses or apportion damages between the impact of defendants' alleged unlawful actions and unrelated negative press. Lively falsely claims that Wagner is planning to opine that defendants did not in fact engage in online manipulation. Using this mischaracterization as a jumping-off point, Lively argues that Wagner is not qualified to offer such an opinion and that the opinion is not helpful to the jury and unreliable. These arguments miss the mark. Wagner will not opine on whether online manipulation occurred. Rather, Wagner criticizes Lively's damages experts for failing to analyze any possible alternative causes of Lively's claimed losses, including a failure to consider and analyze negative press against Lively published prior to the alleged retaliation campaign. Wagner also opines on various other business-related factors that may have caused sales to fail to live up to the projections Kinrick relied on, including an increasingly competitive market and flat sales at Blake Brown's retailer Target. Yeah, it's Target's fault. Target's just did not tell her products very well. And Wagner explains the forecasting problems involved in Kinrick's use of a best case ambition project prepared more than a year before Blake Brown was launched. This is standard rebuttal, and Wagner is eminently qualified to offer this opinion. Wagner also criticizes Lively's experts' failure to apportion damages. For example, Wagner opines that Lively's experts do not perform any analysis that separates out or apportions the impact from defendants' actions versus negative press that has nothing to do with defendants. That is a really good point. That is incredibly important because, not everyone loved her. Like, even if let's just say, right, for a moment, let's just hear me out. Let's just say for a moment, right, Lively proved that Wayfarer somehow smeared her, okay, and caused a backlash. Not 100% of that backlash is ever going to be caused by Wayfarer. Not everyone loved her. As much as she would like us all to believe that, there are people who did not like her products, did not like her acting, don't like her history, don't like her husband. Who will, there are even people who know her, went to school, or have acted with her who have come out. I'm pretty sure Sweet and Salty Lynn has some history. I can't remember. I want to say school, but I'm not 100% sure, so don't quote me on that. But I'm pretty sure, like, she's one of the people that has been discussing this case. She's a content creator, and she organically has a very good reason for not liking Blake Lively. Same with Shusty Flair. It's personal experience of Blake Lively. So, yes, to pass out, okay, even if Lively is successful, the damages, how much are actually due to Wayfarer? If she's not kind of separated out everything, then that's problematic. She can't claim that Wayfarer are responsible for every bad word said about her. And yeah, that's a great argument and a great rebuttal. The failure of Lively's experts to consider and apportion damages to alternative causes is not an opinion on whether online manipulation occurred, much less who was and was not responsible. Although Lively challenges Wagner on the grounds that he did not attempt to quantify Lively's damages, as a rebuttal expert, Wagner is not required to perform an affirmative analysis. Lively claims Wagner's alternative causation criticisms are unhelpful because they depend on the conclusions of defendant's expert Nicole Alexander. Not so. While Wagner notes the opinions provided by Alexander, he explicitly states that those opinions arise in addition to my opinions expressed in this report. Even so, an expert may rely upon the findings of other experts to reach his own conclusions, employing his independent expertise. In Re MV MSc Flamina, although the expert explicitly discusses and repeatedly relies upon the expert opinions of his colleagues who have expertise different from his own, he does so to support his own analysis and conclusions based upon his own expertise. In any event, Wagner's opinion criticizing Lively's experts' failure to analyze alternative causes of loss is not an affirmative opinion as to whether an online retaliation campaign occurred, but a criticism of Lively's experts' failures. Thus, his opinion will assist the trier of fact to determine the reliability of Lively's own experts' opinions. Wagner should be permitted to critique Marks and Sippel's opinions regarding Lively's redacted. Wagner criticizes analysis performed by Lively's experts Richard Marks and Michael Sippel in arriving at their damages opinions related to redacted. For example, Wagner points to a host of factors affecting redacted that Marks did not consider, including redacted. Redacted and redacted? Wagner also criticizes Marks and Sippel for failing to identify redacted, and for assuming without any analysis and contrary to the testimony of her own manager that redacted. Finally, Wagner criticizes Sippel's redacted Precisely the kind of opinions one would expect from a rebuttal damages expert. As a rebuttal damages expert, these opinions fall within Wagner's expertise. Wagner does not offer an opinion on the redacted, but he does note the deficiencies in both Marx and Sippel's analysis. Nor is Wagner's opinion inadmissible simply because he considered the opinion of expert Emmanuel Nunes in forming his opinion. Wagner's report notes that Mr. Nunes's comments are consistent with his own criticisms, namely redacted. Wagner specifically noted in deposition that his opinion would not change even if Nunes's conclusions were incorrect. Lively asserts that Wagner's criticisms regarding Lively's alleged lost earnings are unreliable because he ignores testimony that Lively was committed to working full-time after the release of the film, misunderstands the nature of the offers Lively has received since the film's release, ignores testimony from actual Hollywood professionals, and ignores that Miss Lively's past offers are not an adequate proxy for her future offers, and takes a sliver of deposition testimony from Lively's agent out of context. However, none of these criticisms of Wagner's analysis establish that he did not have access to sufficient facts or data, or that he did not apply his methodology reliably. To the extent Lively disagrees with Wagner, she is free to cross-examine him at trial. Wagner should be permitted to critique Humphreys' opinion on reputational damages. Lively asserts Wagner cannot opine on Ashley Humphrey's reputational harm calculations because he possesses no expertise on how the media ecosystem operates. However, Wagner does not purport to opine on the amount of reputational harm suffered by Lively. He only opines that Humphrey's analysis did not consider that winning a highly publicized lawsuit may help to repair the reputational harm of which Lively complains. Wagner is qualified to criticize Humphrey's methodology in calculating damages based on her failure to consider important factors affecting those calculations. Nor is Wagner's opinion on this point unreliable because he did not provide evidence that her reputational harm would be eliminated. Again, Lively misstates Wagner's opinion. Wagner criticizes Humphreys for not considering that a victory in this lawsuit would go a long way towards restoring reputational harm, thus diminishing her damages. He does not opine that Lively's alleged reputational harm would be eliminated. Conclusion: for all of the foregoing reasons, the court should strike plaintiff's motion for failure to comply with Rule 11 of the Federal Rules of Civil Procedure, or in the alternative, deny plaintiff's motion. That's from Ellen. I love that. That was absolutely great. Yeah, that was a great filing. So there is. I went to have a look to see if because there's an attached exhibit to this motion. I went to have a look, but it is actually still under seal, so I can't show you that for now. We'll see if that gets unsealed eventually. Okay. Let me know what you think. I think this is a really well written response. I love it.